'cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop.
Might be coming round for sure, Shaq.
Let's have a bit of a deeper think about this situation. Imagine you're someone who goes into a coffee shop and you see this barista. And you say, wow, this is a great coffee shop. And the barista goes, would you like to buy it? And you go, yeah, sure. And the barista goes, I'll sell it to you for $1,000. What a deal. $1,000. You can own your own cafe. You hand it over. Bingo, you own the cafe, right? Right? Or do you not? Because what we were just saying was, if the barista, just say they're not the owner, they're working for the owner, so they're the agent, and they can make a contract with a third party, you, that binds the principal. So if they sell the cafe, it's sold, right? No. Why not? Well, it might be sold. We've got to think about it a bit more. And this is the whole problem involved with scope of authority. So just because someone is an agent of someone else, right? We've got an agent and a principal. It doesn't mean that everything the agent says and does is going to bind the principal. They can only do what's within their authority, their scope of authority. But understanding what's within their scope of authority is not that simple, and there's a number of things that we actually have to look at. So let's get into it. When we look at authority, there are 5 key ways you can be authorised to act for a principal. You can have express authority. You could have implied authority. You could have apparent authority. There can be agency of necessity. We're not going to really deal with that. That's a very particular circumstance that I don't think does us a lot of good to look at. And you can also be authorised via ratification. All of these mean you are actually authorised to do the act in question. And what results, the agreement that results, is binding on the principal. So no one type of authority is better than another. They're all valid forms of authority. So express authority is the simplest, right? It's where the principal authorises the agent in writing or verbally. It's expressed. Now, normally you would state the duration of the agent's appointment and the precise scope. But what we have is some form of expression of what you're allowed to do. Express actual authority. Now, implied authority occurs where maybe they didn't actually say you could do what you want to be able to do, but it's implied by the authority that you do have, right? Because in business, we can't foresee everything that you might have to do when you delegate tasks to someone else. So the law will step in and imply an authority to do certain tasks. When will it imply authority? The first way that we get implied authority is when the task that we're talking about is incidental or it's necessary to carry out the authorised act. So let's go back to our cafe and imagine you have express authority to make coffee, right, for customers. Make coffee for customers. And you run out of milk. Now, you don't have express authority to go and buy milk. But look, you can't make the coffee without milk. So you most likely have implied authority to buy milk when you run out. So that means if you go and buy the milk on credit from the store next door, that contract for buying that milk is actually between the store and between the store who bought the milk and your coffee shop, not between you and the store when you buy the milk, right? So that's an example of implied authority. Buying the milk is incidental to your job of making the coffee, which you have express authority to make the coffee, right? You have implied authority to buy the milk. In certain instances, a specific position generally has implied authority. So, for instance, a parking attendant has an implied authority to take money and give change for people entering and leaving the parking station. Right? That's implied, even if it was never written down. And in certain instances, like certain kinds of businesses, like real estate agents, etc., they have certain powers implied. So if it's not written down, it will be implied. A real estate agent can take people to see your house, for instance. Okay, so that's what implied means. It's good to think about it as incidental or necessary to what you are actually authorised to do. Now, probably the most difficult area of authority is this issue of apparent authority. Okay. Now, apparent authority is a difficult area because you might not have been given express authority. In fact, you might have been told that you're not allowed to do something as the agent. But what you do might still bind the principal. There may be actual authority, even though the principal has said they don't want you to do it. Okay. So how does that come about? What's actually going on there? Let's pop in and have a look and understand the logic about what's going on. I think a great case to help us understand this particular problem is Summers and Solomon. So what actually happened here? Well, in this particular case, we've got a jewelry store, right? So we've got this jewelry store, and you've got a guy who owns the jewelry store, and he employs his nephew to manage and run the jewelry store. So you have the uncle, who is the principal, and you have the nephew, who is the agent. So as part of the role of the nephew, he would order and pay for jewelry. Right? So we've got our little pearl necklace. Okay. So the nephew would order this, and the supplier would supply the jewelry and take the money. Okay. So that's what's going on with the nephew here as the manager of the jewelry store. But this nephew was a bit of a no-good kind of person, and the uncle ends up sacking the nephew. Okay, so the uncle sacks the nephew. But before the nephew leaves the store, they've been sacked. Guess what they do? The nephew goes and orders a whole lot of jewelry. Right? The supplier delivers the jewelry, and then the nephew shoots through with all of the jewels. Okay, so the jewelry's over here, and it's lost. Right, the uncle can't get it. The uncle now owes the supplier for the jewelry. So here's the problem. Who loses? I mean, obviously, we should try and get the jewelry back from the nephew, right, and get the money back that way. But the nephew's gone. Can't find him. Jewelry's gone. Someone has to lose. Who should lose? The uncle or the jeweler? Because at the time of ordering, the nephew never had authority, never had express authority to actually order that jewelry from the supplier. But when you think about it from the supplier's perspective, right, how do they know that? They've always had this nephew ordering off them, and it's just a normal order, so they supply it. So what the law does in these instances is it has a set of rules to work out where there's apparent authority, where it looks like one of the parties has authority. And if it looks like they have authority, then they actually have authority. So in this case, the uncle did have to pay for the jewelry, even though he had expressly sacked the nephew. He had to pay the supplier. Why? Because when the nephew ordered it, they had apparent authority. So what's the rule that allows us to do that? Let's hop in and have a look. So there are three things. And again, I want to stress, as I always do, that this is an and test, so you need all three. The first thing is the third party must not know that the agent did not have actual authority. So in our case over here, right, the supplier must not know that the nephew's been sacked, right? And the supplier didn't, right? If the supplier knew that the nephew didn't have authority, then there'll be then there's no apparent authority. But here the supplier didn't know that the nephew didn't have authority. Okay, what's the second element? So we've got a tick for Summers and Solomon here. What's the second thing? The principal must hold out the agent as having authority. So the principal must do something. They must hold them out to make the third party think that the agent has authority. So here, the uncle, right, appointed the nephew and allowed the nephew to order in the past. That's what the principal did. So the principal did do something to make the supplier think that the nephew had authority. They'd done that in the past. So that second one is satisfied. Yes, the uncle had done something to make the supplier think the nephew had authority. And the third party relied on that holding out and reasonably assumed the agent had actual authority. So it was reasonable to assume, look, this was just a normal transaction. They'd been doing it for a long time. So it was quite reasonable to think that the nephew actually had authority. They didn't know they'd been sacked. And so that was met. So if you meet these three conditions, then the agent has authority, no matter what the principal says. Now, I hope you can see why that makes sense, right? Because in a way, the person taking the risk in business here is the person doing the employing, the principal, the uncle. The uncle is the one who hired the dodgy nephew. So if there's a loss, it only makes sense really that probably the uncle should bear that loss if you can't get the money back from the nephew, right? It's probably not right that the supplier, and think of how business would operate if suppliers always had to check that the delegated person has authority. They'd be constantly checking, do they still have authority? Do they still have authority? No. So now the law reverses that onus and says, look, if you sack someone and they order for you, you better make sure that everyone knows that they no longer have authority, right? And that's why often when people leave a job, they'll send out a note saying, Gavin no longer works for us. Why? Because now you know that I no longer have authority to order for you, for instance, right? So that's why we have business practices like that as well, as part of these laws that evolved over time.